Good morning. Welcome to EduSet Network. Friend, we are discussing fundamental rights, and so far we have covered a number of articles up to 22. And in the article 22, we were discussing about the constitutional safeguard against arrest made under general law, and today we will discuss the constitutional safeguard against arrested against preventive detention. And for discussion on this very topic, we have in the studio Dr. Rakesh Kumar. He teaches in University School of Law and Legal Studies in Guru Gobind Singh Indraprasth University and has a specialization of constitutional law. So I think his knowledge and experience and the way he teaches will help us to understand this topic and help to interpret this article under the article 22nd constitutional safeguard against preventive detention. So on your behalf, I welcome him for EduSet lecture on this very topic. Welcome, sir.
Thank you, sir. Good morning, listeners. In my previous lectures, when I was discussing Article 21 of the Constitutions, then what I said, the Article 21 provides that no person shall be deprived of his life and personal liberty except the procedure established by law. It simply means a person can be deprived of his life and personal liberty provided that deprivation is brought by the procedure established by law or the procedure which is following the mandate of the due process of clause as interpreted and incorporated by the Indian judiciary. So these minimum procedural safeguard is being provided by Article 22 of the Constitutions, and Article 22 discuss with the two different aspects of the procedure which has to be followed by the executives if any person is being arrested under the ordinary law and if the person is arrested under the preventive detention law. In my previous lectures, I have already given you a detailed explanation as to what kind of the rights which are available to the persons if he is being arrested under the ordinary law and what kind of the precaution has to be exercised or has to be taken by the executives if he is going to make an arrest under the ordinary law. And I have tried to explain the detailed aspect of Article 22 clause 1 and 2 with the help of the guidelines which was given by the Supreme Court in the D.K. Basu case, Joginder Kumar case as well as the Anupam J. Kulkarni case. And then in my previous lecture on Article 22, I have already given you the brief idea as to how the preventive detention is different from the detention which is made under the ordinary law. Because in preventive detention law, person is not being arrested for any crime which he has committed, but they are being taken to custody before he go and commit the crime. So the sole justification for preventive detention law lie in the mere suspicions or reasonable justification in the mind of the executive that if the person is not prevented, not taken to custody, then there is every possibility that he may go and commit the crime. So basic objective of the preventive detention law is to prevent the persons from indulging in any kind of the anti-social or subversive element. In my previous lectures, I have already explained to you that under the entry 9 of the list 1 of the 7 schedules as well as the entry 3 of the list 3 of the 7 schedules, both the state government as well as the union government will have the power to make a preventive detention law. And in my previous lecture, I have already explained you the genesis of the various preventive detention law which was enacted time to time in the free India, starting from the Preventive Detention Act of 1950, which was allowed to continue till December 1969. Then we have explained you the genesis of the MISA, that is Maintenance of Internal Security Act 1971. Then the Prevention of Black Marketing and Maintenance of Supply of the Essential Commodity Act 1980, which is still in the force, and the National Security Act 1980, which is still in force, along with the other form of the preventive detention law like the prevention of the illicit trafficking, the narcotic drugs and psychotropic substance in 1988. These preventive detention law is still in force. And today in lectures I will try to explain you as to what kind of the safeguard which is available to the person if he is detained under the preventive detention law. If you see the provisions of clause 4 to 7 of Article 22 of the Constitutions, then it provides the three kind of the safeguard to the persons who is detained under the preventive detention law. The first safeguard which is provided by the Article 22 clause 4 is that the no detentions beyond 3 months unless such detention is approved by the advisory board. And the second safeguard which is provided by the Article 22 clause 4 is that the detaining authority must communicate as soon as maybe to the detainee the ground for such detentions, which is provided by the Article 22 clause 5. Then third safeguard which is provided provided under Article 22 is that the detainee must be afforded the earliest opportunity of making representations against the order of detentions. And today I will take up the detailed aspect of the each and every safeguard which will be provided by the various clause of Article 22, namely the clause 4 to 7 of Article 22. Now come to the first safeguard, that is the safeguard that pertains to the review by the advisory board. Now here you first try to see what were the provisions which was available in the constitutions, and what kind of the change which is being sought to be proposed by the Constitution's 44th Amendment Act. You have to keep in mind here that the Constitution's 44th Amendment Act, which was passed by the both House of the Parliament, but still it is not brought into notification, it is still not brought into force. So we have to comply with only the provisions which was available before the 44th Amendment Act. Now you see the provisions prior to the 44th Amendment Act. It says the clause 4 provides that no law providing for preventive detention shall authorize the detention of persons for a period longer than the 3 months unless an advisory board constituted of a persons who are or have been qualified to be judge of the High Court has reported before the expiry of the said period of 3 months that there is a sufficient cause for such detentions. So if you see the provisions of clause 4 of the Article 22 of the Constitution, here if the executive has decided to take any persons under the preventive detentions, then that case from the date of detentions within 3 months they have to refer the matter to the advisory board, and before the expiry of the period of 3 months the advisory board is required to give his opinion as to whether there was sufficient cause or sufficient justifications for carrying out such preventive detentions or not. So if the matter has been referred to advisory board, and if the advisory board has given its opinion that there was sufficient justifications for detention of such persons, then that case detaining authority shall determine what will be the quantum of detentions. Definitely the detentions cannot be for indefinite period of time, and you always have to keep in mind that preventive detentions law, person detained not for any crime which he has committed, but he is detained merely on the anticipations of commission of the crime if he is not immediately taken to custody. So as far the role of advisory board is concerned, advisory board is merely required to give his opinion regarding the justifications of the detentions. So once they have given the justifications, then that case it is for executive to decide as to what will be the period of detentions. And if you see the clause A of the Article 22 clause 4, then here it also provide for the constitutions of the advisory board as to here if you see the constitutional provisions before the 44th Amendment Act, here the constitution of advisory board has been left totally to the discretions of the executives. And if you see the provisions of clause A of Article 22 clause 4, then say the advisory board shall be constituted of persons who are or have been qualified to be a judge of the High Court, who has reported before the expiry of the period 3 months that there in his opinion sufficient cause for such detention. So it means it is for the executives to decide as to who will constitute the member of advisory board, and the only qualification which is prescribed by the clause A of Article 22 clause 4 sub clause A is that he has been or qualified to be judge of the High Court. But if you see the change which has been introduced by the Constitution's 44th Amendment Act, here earlier the executive is required to refer the matter to advisory board, and in their turn the advisory board is required to give its opinion within the expiry of the period of 3 months. The change which has been introduced by the Constitution's 44th Amendment Act is that once the person had been taken to detentions under the preventive detention law, then detaining authority is required to immediately refer the matter to the advisory board, and advisory board will be under obligations to provide its opinion regarding the justifications for such detentions within the period of 2 months. So the first significant change which has been introduced by the Constitution's 44th Amendment Act is that the period during which the advisory board has to give his opinion has been reduced from 3 months to 2 months. The second significant change which has been introduced regarding the constitutions of advisory board. Earlier, what is being provided that the advisory board shall consist of the persons who are or have been qualified to be judge of the High Court. But after the Constitution's 44th Amendment Act, what is being provided that the advisory board shall be constituted in accordance with the recommendations of the Chief Justice of the appropriate High Court. So the power of appointment of advisory board is now being taken out from the hands of the executives, and now the responsibility has been entrusted to the Chief Justice of the High Court to constitute the advisory board. And the second significant change which is being introduced by the Constitution's 44th Amendment is that the persons who will act as the chairman of the advisory board, he will be the sitting judge of the appropriate High Court, and the two others member who will be the part of the advisory board, he may be either a sitting or retired judge of any High Court. So the significant which has been introduced by the 44th Amendment is that now the advisory board shall be constituted on the recommendations of the Chief Justice of the High Court, and the chairman of the advisory board will be the sitting judge of the High Court, and two others member will be either the sitting or retired judge of the High Court. So the power of constitutional advisory board is now completely taken out from the power of the executives. Now it is for judiciaries to regulate the constitutional advisory board, but however the functions of advisory board is concerned, they have the very limited power. They can only give their opinion regarding the justifications for such detentions. So once they have given the justifications regarding the detentions, then that case it is for detaining authority to decide as to what will be the period of detentions. Now I am coming to the judicial interpretations to the preventive detention law. The first case I have taken the Abdul Latif Abdul Bahi versus BK Jha case. This case was decided by the Supreme Court in year 1987. Here in this case, the fact of this case was that the petitioners were detained under the preventive detention law, but the first preventive detention order was being revoked by the executives, and the fresh order for detention was being made. And after the fresh order of detention was being made, then matter was being referred to advisory board, and advisory board has given an opinion. But if you see the opinion which was given and the time which was taken by the advisory board in giving the opinion, it was beyond the period of 3 months from the first order of detentions, but it was within the period of 3 months from the second order of detentions. So the constitutionality of this order was being challenged before the Supreme Court, and the Supreme Court has to decide as to whether there was sufficient compliance of the requirement of Article 22 Clause 4, which mandate that the opinion of advisory board must be obtained within the period of 3 months from the date of detention. So issue exactly before the court was whether such constitutional obligations can be evaded by the executives by making the successive order of detentions. Here the Supreme Court said that detentions order was illegal and it was violative of Article 22 Clause 4, which required that the report of the advisory board must be obtained within 3 months from the date of detentions. So this requirement cannot be evaded by making a successive order for detentions before the expiry of the 3 months of the earlier order of detentions. And the court further remarked that detentions order was passed knowing fully well that there was no advisory board in existence to whom the reference could be made, and the report obtained as required by the Act and the Constitution. So such a casual and indifferent approach to the citizens' rights has to be condemned. So in this case, here the requirement of 3 months must be strictly followed by the executives, and they cannot simply evade the constitutional requirement by making the successive order of detentions. So from the date of the first order of detentions, here this period of 3 months has to be counted, and within this period of 3 months, the executive has to approach to advisory board, and they have to seek their opinion regarding the continuations of detentions. If the advisory board has given the opinion that there was not a sufficient justifications for such detentions, then that case detaining authority will be duty bound to immediately revoke the detentions and the person will be free. If they have given the opinion regarding the sustainability of detentions, then that case they will decide about the period of detentions. The other important case is the Nandlal versus State of Punjab. This case was decided by the Supreme Court in 1981. Here this case, the constitutionality of section 11, 12 and 13 of Prevention of Black Marketing and Maintenance of Supply of the Essential Commodity Act 1980 was being challenged, where it was being allowed the legal assistance to the state before the advisory board, but not to the detainee, as violative of Article 21 as well as Article 14 of the Constitutions. Because if you see the procedures before the advisory board, here the advisory board is only required to give his opinion, and before the advisory board the detainee is not having any right of legal representations. They are not having right to be represented by the lawyers. They are not having right to go for the cross examinations of the witness which might be produced by the state for justifying the detentions. So in this case, but what happened in Nandlal case is that the state was being represented by the battery of the lawyers, and they have tried to justify the detentions before the advisory board, but the same right was being denied to the detainee by saying that they are not having any constitutional right to be represented before the advisory board by the help of the lawyers. So in this case, the issue before the court was to whether in such case advisory board was constitutional right in denying of the such right to the detainee. Here the Supreme Court said that if the advisory board had decided to give this kind of privilege or benefit to the state, where the state was being represented by the lawyers to justify the detentions, then there is no justifications to deny the same kind of right to detainee. So it has the implication that if the state is being represented by lawyers, then that case advisory board will be under obligations to provide the same kind of amenity to the detainee also. So he will also present his case regarding whether the justification was justified or it is based on the suspicion which is unfounded and it is not based on any solid foundations. Now I am coming to the other case, that is Hitendra Vishnu Thakur versus State of Maharashtra case. Here in this case basically pertains to the TADA. Here this case, the constitutionality of section 167 clause 2 of the CRPC was being challenged, because here in this case, here the indefinite time period has been allowed for the detentions. Here the Supreme Court has said that the section 167 clause 2 clearly laid down the time period during which the police has to carry out the investigations, and if the police fail to carry out the investigation within the stipulated period of 180 days, then that case the detainee will be entitled to release on bail. Now we come to the second important safeguard which is provided in the preventive detention law, that is the right of detainee to be informed of the ground of detentions. As far the right to be informed about the ground of detention is concerned, this is provided by Article 22 clause 5, and it provides the detaining authority as soon as may be communicate to the person detained the ground of his arrest, and second, to give the detainee the earliest opportunity of making representations against the order of detentions, that is to be furnished with sufficient particulars to enable him to make effective representations. So ground of arrest has to be communicated, and they must be given the opportunity to make representations against such order of detentions. And the third important component of this right is that the ground must be in existence at the time of arrest itself. So now come to the first word, that is the word communicate. So what the word communicate signifies? If you see the constitutional interpretations to the word communication as being used under Article 22 clause 5, here the word communicate is a strong word, and it required the sufficient knowledge of the basic fact constituting the ground that shall be supplied effectively and fully to detainee in the writing in a language which he understand. So it will enable him to make a purposeful and effective representations before the advisory board. So once the person is being taken to preventive detentions, then detaining authority and the constitutional obligations to provide him as to what are the grounds, what are the basis on which they have been detained. And it is not only that the ground has to be communicated to the detainee, it also has to be communicated to him in a language which he understands best. Suppose the person is a South Indian, and if he is not well versed with the Hindi, if he is not well versed with the English, then that case the ground of detentions must be communicated to him in a language which he understands best. Sometimes here the difficulty will arise. Suppose the persons may put his signatures in English. Merely by the fact that he has put his signature in English does not indicate or signify the person had the sufficient working knowledge of the English. So in that case, here for detaining authority, it is the obligatory for detaining authority to inquire as to in what language he is more comfortable, and if he say he is more comfortable in that particular language, then the ground detentions must be communicated to him in that language only. So he will be well versed with the what are the ground on which he is being detained. As far the communications of the ground detention is concerned, here it is not necessary that the full details or the full particulars of the all the material source which has been taken to considerations by the executives for carrying out such detentions must be communicated to him, because sometimes the communications of all such informations may be prejudicial to the security state, it may be prejudicial to the maintenance of the public order, because once you have been ground has been communicated to you, then you have the right to consult your lawyers and you have to give your representation. So moment you are consulting your lawyers, it will not remain though it will be a privileged communications, but you cannot ensure that this communication is confined only to lawyers. There is every possibility that the such kind of communication informations may travel outside the knowledge of the minds of the lawyers also. So this is the practical aspect. So here it is not necessary for them to disclose the source of information also. The executives may have the different source, so disclosing of the source information is not necessary, but what constitutes the material ground, what constitutes the fundamental ground or the basic ground, that must be communicated to him, so he will be in positions to make a effective representations to the before the advisory board or before the appropriate government. Now I am coming to the case of Hari Krishnan versus State of Maharashtra. This case was decided Supreme Court in year 1962. Here in this case, Supreme Court said when the ground of detentions was verbally explained to detainee and nothing in writing is left to him in a language which he understand, then the purpose of Article 22 Clause 5 is not being served and their constitutional right is being infringed. So it is not merely the verbal communications of ground that will be sufficient. What is required that apart from the verbally explaining him the ground detentions, the executive also required to leave it in a black and white in a language which he understands. So once he will have the particulars, he will go through those details and he will effectively prepare his representations before the advisory board or before the appropriate government. Now I am coming to the case of Siban Lal versus State of UP. Here in this case, what happened in this case, that here the persons were detained the preventive detentions law, and at the time of the first detentions, there was stated to be 2 grounds on which the person was being detained, and later on the detaining authority has revoked 1 grounds which was communicated to him earlier, and they have tried to justify the detentions on the 2nd ground only before the advisory board. Here the detainee has challenged the detentions by saying that his detentions was illegal. So in this case, issue before the court was if the 2 ground was being communicated, and suppose if out of these 2 grounds, if the 1 ground is being withdrawn by the executives, but in that case it is somehow going to vitiate the detentions of such persons or not. Here in this case, the Supreme Court held that the detentions of such persons was illegal, and the Supreme Court had laid down the certain yardstick or guidelines by saying that to say that the other grounds which still remains quite sufficient to sustain the detention order, would be a substitute on objective judicial test for the subjective satisfactions of the executive authority, which is against the legislative policy underlying the statute. So in this case, the court has categorically stated that if the out of two grounds, if the one ground is being withdrawn, then it will make the detention illegal and the person would be entitled to be immediately released on bail. Then we have the case of Muhammad Yusuf versus State of J&K. In this case, Supreme Court has gone ahead by saying that inclusion of if the single irrelevant or obscure ground is an invasion of the detainee's constitutional right, because it precludes the court from adjudicating upon the sufficiency of the ground. So if the executive is going to detain any persons under preventive detention law, then that case he has to make it doubly sure that there is not a single irrelevant ground is being incorporated under the order of detentions, and all the ground detentions must be communicated to him. And this point has created a difficulty for the executives, because whenever the executives at the time of because if you see the provisions of National Security Act, then under these provisions what is being provided that within the 10 days from the date of arrest, the executive authority is required to communicate him the ground of detentions, and within 10 days it may be possible that because here the person is being taken to custody not on the basis that he has committed any crime, he is merely taken to custody on the anticipations that if he is not taken to custody immediately, then there is a possibility that he may go and commit the crime. So whatever the suspicion on the basis of which the executive has founded or executive had decided to go for preventive, it may be possible that such justifications may lapse because of the lapse of the time. So in that case, the amendment was being introduced in the National Security Act in 1984, and what is being provided by the amendment is that the detention order made under the act for which two or more grounds have been mentioned would not be deemed to be invalid or inoperative merely because some of the grounds are considered to be vague, non-existent, non-relevant, unconnected or invalid. So it simply means if one of the ground was found to be bad and unsustainable, then detentions under the National Security Act would not be vitiated if the remaining grounds are found to be valid. So this important safeguard which was being introduced by the Constitution's amendment to the National Security Act, now we say that if the one ground is not sustainable, but if the other ground is sufficient to justify detentions, then it will not make the detentions of such persons illegal or unjustified. Now coming to the third component of the rights which is provided in preventive detention law, that is the right of representations. What I said, the detainee must be furnished the sufficient particulars of the grounds of the detentions to enable him to make a effective representations. So as far as the ground is concerned, all the basic fact and material which was taken into account by the executives before carrying out detentions, it must be communicated to him. And it is not only the communication of the ground, here the executive is also under responsibility to provide or to afford him the enabling provisions, so it will make him the effective representations, and that effective representation has to be heard by the competent authority. As far as if you see the constitutional provisions, there it is not being provided that the detainee has to make a representations before whom. Constitution is silent on this aspect. So if the person is being detained and if the matter is being referred to advisory board, then definitely in that case advisory board will be under obligations to inquire from the detainee as to what he has to say with respect to that ground of detentions. And if the detainee is not willing to come forward before the advisory board, then that case advisory board will justify for detentions merely on the basis of the ground which was furnished by the executives. Then the second thing is that the right to representation. So here the detainee has the two rights. There is a two possibility. either the detainee can make a representations before the advisory board, and if such representation is being made before the advisory board, then that case advisory board will be duty bound to consider the representations which was being made by detainee. The other possibility is that the detainee may prefers to make a representations before the government. So if they are making representation before the president or governor, then that case it will presume that he has made a representations before the central government or before the state government, because what is happening that the persons may be arrested by the executives and their arrest may be regulated or controlled by the respective department headed by the particular minister. So what is happening in that case, if the matter has been referred to has been communicated to president governor, then that case they will refer back to the concerned ministry or concerned department, and the concerned departmental authority will be under obligations to decide about the representations. So as far the considerations of the representations made by detainee by the concerns government authorities concerns, it will not be considered as a substitute for the representations which was being considered by the advisory board. Advisory board will consider representations on the basis of their own objective assessment, and the government is under constitutional obligations to consider the representations on the basis of their own subjective satisfaction. So they will consider detentions, and after considering detentions they are under obligation as to justify to communicate to detainee as to whether the representations was taken to account by the executives or it is not being entertained. So you see these kind of rights which is provided by the persons who is detained under the preventive detention law. So it will give the opportunity to the executive also to consider as to whether there was sufficient justification or not. So after considering the representations, if it appears to the executive that there was not a sufficient justifications or the apprehension on which the such detention was being made is unfounded, then that case executives will be justified to revoke the detentions and release the persons. In that case executives will not require to refer the matters to the advisory board. Then I am coming to the other important aspect, that is Article 22 clause 6. This is the exceptions to the clause 5 of Article 22, and it says that the disclosure of fact which are considered to be against the public interest may not be furnished to the detainee. So if the executives apprehends or they consider that disclosure of any facts involved therein is against the public interest or where it is against the security state, then that case detaining authority may refuse to communicate in the ground retentions. But in that case they have to communicate that they have decided not to communicate the ground detentions because they consider it is against the public interest or it is against the safety and security of the nations. So these kind of the rights, these kind of the safeguard which is being provided by Article 22 clause 4 to 7 of the constitutions. And one more thing you have to keep in mind, that the two exceptions which is being recognized under Article 22 clause 7 A and B. The one of the exception that it may be possible that the parliament may by law prescribe that the certain class of the offences or the certain class of the cases where it is not necessary to refer the matter to advisory board. So this power is given only to the parliament, and the parliament has enacted any law and they have provided, then that case the provisions of Article 22 clause 4 shall not be applicable, and that case it will not be incumbent on the executives to approach to the advisory board for seeking justification, just to seek their opinions regarding the justification. So if the class of cases is being delineated, then that case they are not required to refer the matter to advisory board. So in this way I have tried to comprehend each and every aspect of the Article 22 of the constitutions, where the very important safeguard is being provided to the persons who is detained under the ordinary law as well as the person who is detained under the preventive detentions law. After covering this, now we come to the next important article, that is the right against exploitations, that is being dealt under Article 23 and 24 of the constitutions. Now you see the the what kind of the right which is being provided by Article 23 and 24 of the Constitutions, and who are the persons who are entitled to claim the rights which is being provided by Article 23 and 24 of the Constitutions. When I started discussing the fundamental right, at that point of time I have told you that you can simply imagine the sensitiveness on the part of the Constitution's maker, because they just wanted to protect the people of this country, they wanted to protect the citizens of this country from any kind of exploitations which is sought to be justified on any of the basis or any of the customary provisions. So, if you see the provisions of Article 23 of the Constitutions as well as the Article 24 of the Constitutions, it guarantees the fundamental right to the every persons, that is the citizens as well as non-citizens, and under these provisions the protection is available against the state as well as the private individuals. So, as far as the Article 23 and 24 is concerned, here this right can be enforced not only against the state or its instrumentality, but this right can also be enforced against the private individuals. Now, I am coming to the substantive aspect of Article 23. It says the traffic in human beings, beggars and other similar form of the forced labor are prohibited, and any contraventions of this provision shall be an offence punishable in accordance with the law. So, if you see the essential ingredients of Article 23 clause 1 of the Constitution, precisely the first part of Article 23 clause 1, it provides the prohibitions against the traffic in human beings, and second, it also prohibits the system of the beggars and other forms of the forced labours. So, now I am coming to the first aspect as to what is the meaning of the traffic in the human beings. As far the terms traffic in the human being concerned, it simply means dealing in human beings like a chattels. It simply implies that the buying and selling of the man and women like a goods, and it is not only the buying and selling of the man like goods, it also includes the all kind of the immoral traffic of the women and girls, or subjecting to the children to the immoral or such other practice. So, it is not only that the buying or selling or the slavery which is prohibited, or the traffic of the women or children is prohibited for the immoral purpose. Here this article is interpreted to incorporate the term system of slavery also, though slavery is not specifically mentioned as one of the components or words under Article 23 clause 1 of the Constitution, but judiciary has interpreted as the slavery is also one of the kind of the prohibitions, and it has to be prohibited, it has to be abolished. Now, coming to the interpretations as far as the trafficking in the women and girls is concerned, particularly for the using them for the immoral purpose is concerned, here this issue has drawn the attention of the court in the Bisal Jeet versus Union of India case in year 1990, where the Supreme Court has issued directions to the state government as well the union territory for eradicating the evils of the child prostitutions and for evolving a programs for the care, protections, treatment, development as well as rehabilitations of the young fallen victims. So, here the Supreme Court has directed the respective state and the union territory that they have to take a positive step for eradicating the evils of the child prostitutions, and they have to devise the mechanism for the somehow just taking out such girls who are somehow being thrown in this prostitution racket, and they have to provide the mechanism for their rehabilitations. As far the second aspect of Article 23 is concerned, here what is provided that any contravention of this provision shall be an offence punishable in accordance with the law. So, Article 23 clause 1 not only prohibit or prevent the traffic in the human beings, begar or other form of the forced labor, it also obligates the state to make a law for providing punishment for any persons or any of the state instrumentally if they indulge in any kind of the activity which is being prohibited by Article 23 of the Constitution. And just to give the mandate to these provisions under Article 35 of the Constitution, here the Parliament has enacted a specific act, that is called the Suppressions of the Immoral Traffic in the Women and Girls Act 1956, and this act was being renamed as the Immoral Traffic Prevention Act 1956. And here this provision has to be read along with the Article 39 clause E and F of the Constitution, where the state is under obligations to protect the children as well the youth against the exploitations and against all kind of the moral and material abandonments. So the state was having the definite constitutional obligations under Article 39 clause E and F, and apart from this they have been given the specific mandate under Article 23 clause 1. Just to ensure those provisions, they have enacted the specific provisions under Article 35 of the Constitution, which empower the state to take a positive step for protections of the persons who were engaged or who were thrown in the immoral trafficking. Here this issue was also drawn the attention of Supreme Court in the Gaurav Jain case. This is also one of the landmark decisions of the Supreme Court, where the 3 judges of the Supreme Court has held that the problem of prostitutions had become one of the serious natures and required a considerable and effective attentions. So the court issued directions to the for the constitutional committee to examine the problem and for the segregations of the children of the prostitutes from their mothers who were living in the prostitutes' homes, and allow them to mingle with the others members and become the part of the society. So the child prostitution was being sought to be addressed by the Supreme Court in Gaurav Jain case also. Now I'm coming to the second important component of Article 23 clause 1, that deals with the begar. Here, as far as the term begar is concerned, it is of Indian origin, and it means the involuntary work done without the payment. So as far as the begar is concerned, it implies the two things. First, it is to compel a person to work against his will, and second, he is not being paid any remunerations for the work, or if any remuneration is being paid, that remuneration is less than the minimum wages act. So if any person is being paid wages less than minimum wages act, then it will amount to the begar, and it will amount to the one form of exploitation which is sought to be prohibited by Article 23 of the Constitution. So begar simply means the labor or service exacted by the government or persons in power without giving remunerations for him. Sometimes you might have seen that you might be having some kind of the customary practice, and under that customary practice it may be possible that the person is required to provide a free labor or free service to the village headman or the village mukhiya. So if you have this kind of constitutional practice, and if this kind of practice is being propagated by saying that it is being followed by the time immemorial, naturally the questions will arise whether such kind of the customary practice can be allowed to continue by saying that it is having the status of law in the view of Article 23 clause 1 of the Constitution. As far as the Article 23 of the clause 1 of the Constitution is concerned, it absolutely prohibits all form of the involuntary works or the work which is being done without any kind of remunerations. So if any customary practice, if he mandate for the providing this kind of the free service, then definitely such customary practice cannot allow to exist, and it will definitely in violations of Article 23 clause 1 of the Constitution. Apart from this, sometimes you might have seen that the village, because you have the grassroots democracy, and under such grassroots democracy, here the panchayat may issue order, and panchayat may require that every person has to provide some kind of the free service or the free labor for providing some kind of amenity which may be used by the village in general. Now again, the constitutionality of this order can be challenged on the basis of Article 23 clause 1, because it amounts to begar, it amounts to the work which is being provided or labor which is being tendered without any remissions. So even the panchayat is not having any kind of the legal right to pass this kind of order, where it will require that the villagers of that locality has to provide their service for enactment of any kind of amenity which might be used by the villagers at large. So if the panchayat wants that the service has to be utilized, then that case the person who is providing service, they must voluntarily willing out to come and provide the service, and they must be provided the minimum wages for providing that kind of services. So, and the third aspect, suppose if the person is being engaged for doing a certain kind of work, and if later on is found by the employer the kind of work which is being provided by them, it is not satisfactory, then within that case they can refuse to pay wages, and if they refuse to pay wages on the ground that there was not a satisfactory work, then it will also amounts to begar and it will violations of the constitutional right under Article 23 clause 1. So, any such employer who is refusing to pay minimum wages merely on the basis that they are not satisfied the work, they are violating the provisions of Article 23 clause 1. For that they can made accountable by the state. Now I am coming to the other aspect, that is the if some persons might enter into the kind of personal contract, and under that personal contract they may require to provide the service, and if they are refused to provide the service, then they will be subject to the punishment. So, if they have entered this kind of the contract where they have required to provide service and they will be subject to punishment if they refuse to do so, then such personal contract cannot allow to coexist, because it will presume to be violative of Article 23 clause 1, because in such case the kind of service which will be provided, it will presumes to be involuntarily, it will presume to be against their will or their wish. Apart from this, but if the person has entered a kind of personal contract, and by that personal contract if it is provided that the person refused to honor the contract, then they will be subject to civil liability or civil liability. Then that case such provisions can be upheld, because in that case there is no elements of the any kind of the compulsions to the persons to provide the involuntary works or coercive work or compulsive work. Then the other aspect which pertains to Article 23 clause 1 is that the suppose what will come under the meaning of the term forced labor. Suppose person whether the forced labor will comply only with respect to the physical force or coercions, or it will cover the other aspect of the economic disability or the social disability. So, here as far as the term forced labor is concerned, under Article 23 clause 1 of the Constitution concerns, it has been interpreted judicially as to any kind of the compulsion, whether it is a physical compulsion, whether it is a economic compulsions or it is a social disability. All kind of compulsions, all kind of the coercions are being prohibited by Article 23 clause 1, and no one will be compelled to do anything which is not according to the will, which is not according to the wish. Now we come to the other dimensions of the forced labor, that is the here this issue was being considered by the Supreme Court in PUDR versus Union of India case in 1982, where it was being provided that the Article 23 clause 1 would strike at the forced labor, and in whatever forms it might manifest itself. So, it thus prohibited not only the beggars or other unpaid labor, but it also prohibited compelling all unwilling laborers, whether paid or not. So, any amount of remunerations paid to a person will be immaterial if the labor is forced upon him. Here the force compulsions, the force or compulsion issue under Article 23 clause 1 is also being considered by the Supreme Court in Sanjit Roy versus State of Rajasthan case. This is a very peculiar case. Here the constitutionality of the Rajasthan's Famine Relief Works Employee Act 1964 was being challenged. Here what is being provided by this Rajasthan Famine Relief Works Employee Act, that it exempted the applications of Minimum Wages Act, and what is being provided that if any person is being engaged under the famine relief works, then they will not demand the minimum wages, and they have to confine himself with only whatever the wages that will be provided by state, because the state wanted to provide the some kind of help to the persons who is being hit by the famine. Here the constitutionality of this act was being challenged before the Supreme Court, and Supreme Court has negated this provision by saying that the state could not take advantage of the helplessness of the famine affected persons and pay them less than the minimum wages on the ground that it was given to help or to meet the famine situation. So, even the person is being engaged in the famine relief work, they have to be paid by the Minimum Wage Act, and state cannot take any kind of plea, and state cannot pay less than what is being mandated by the Minimum Wage Act. Then the other issue which pertains to the forced labor, that the suppose a person has been subject to rigorous imprisonments, and as a part of rigorous imprisonment, if he is assigned some kind of the rigorous work, so whether the impositions of such rigorous work will also be considered as a violative of Article 23 clause 1, because when I was discussing the Article 21, then what I said that if the person is being when I was Article 21 as well the Article 22, then what I said, the persons if he is arrested, then he may put inside the jail, he will not have the freedom to move out of the jail, but he will have the residuary of the rights, he will have the right to dispose of the property, he will have the right to co-mingle with the other co-prisoners. So whether the such person who is being subject to rigorous imprisonment, and if under the such rigorous imprisonment, if the person is required to do the compulsory coercive work, whether such impositions of the compulsory coercive works will tantamount to violations of Article 23 clause 1 of the Constitution. Here with respect to this, Supreme Court has clarified in the state of Gujarat versus Honorable High Court of the Gujarat case, that if the person is being lawfully arrested and put inside the prisons and sentenced to rigorous imprisonments, and if they are required to do hard labors as a part of punishment, whether he has consented for that or not, then it would not be violative of Article 23 clause 1. So if any kind of the involuntary work which is being provided or tenders, and if it is a part of the rigorous imprisonment sentence which is awarded by the court, then it will not be violative of Article 23 clause 1 of the Constitution. Now I am coming to the exceptions to the Article 23 clause 23 of the Constitution, and that is being provided by Article 23 clause 2. If you see the provisions of Article 23 clause 2, here it enables the state to impose the compulsory service for the public purpose. So however, while imposing such kind of the compulsory service, state is prohibited from making any kind of discriminations on the grounds of religion, race, caste, class, or any of them. So if it appears to the state that some public purpose has to be served, or the service of some person is required in the interest of the nations, in the safety and security of nations, then that case here the general interest of the community will be considered greater than the interest of the particular individuals, and they may be subject to the compulsory work under the Article 23 clause 2 of the Constitution. So the public purpose simply means the general where the general interest of the community is directly involved. So definitely it will include the social and economic objective which is being provided by the directive principle of state policy. So as far the term public purpose is concerned, here the Supreme Court, the Madhya Pradesh High Court in Devendra Nath Gupta versus state of Madhya Pradesh has said the kind of the work which will be included in the term public purpose include the educational survey, family planning, preparations of the voter list, preparations of the ration card, etc. So if any person is being engaged in providing these kind of services, and if such person is not being paid any remunerations, or if some person is merely being paid an ordinary amount, then that case it would not be violative of Article 23 of the Constitution, and taking out of such service will be considered as part of the public service as mandated by Article 23 of the Constitution. So this is the way how the Supreme Court has interpreted the nature and scope of Article 23 of the Constitution. And one more thing you have to keep in mind with respect to Article 23, that if there is a conscriptions for defense of the country or social service, then such kind of the imposition of work is well protected under Article 23 clause 2 of the Constitution, and it would not be considered a violative of the citizens' right under Article 23 of the Constitution. Now I am coming to the next article, that is Article 24 of the Constitution, which provide for the provisions of the employment of children. If you see the verbatims of Article 24 of the Constitution, it say that no children below the age of 14 years shall be employed to work in any factory or mine or engage in any hazardous employment. So Article 23, Article 24 is not an independent provisions. If you wanted to decipher the nature and scope of Article 24, then you also have to keep in mind the provisions that is being provided by Article 39 clause E as well as Article 39 clause F of the Constitution. If you see the provisions of Article 39 clause E of the Constitution, it is under the directive principle of state policy. It mandates the state to protect the health and strength of the workers and the tender age of the children, and to ensure that they are not forced by the economic necessity to enter into any kind of avocations which is unsuited to their age or strength. And similarly, if you see the provisions of Article 39 clause F of the Constitution, it says the children are to be given opportunity and facility to develop in a healthy manner and in conditions of the freedom and dignity, and the childhood and the youth are to be protected against the exploitations and against the moral and material abandonment. So if you see the provisions of Article 39 clause E and F of the Constitutions, here state is under obligations to provide the enabling conditions which will ensure the healthy development of the child, and at the same time they should not be subjected to any kind of work which are unsuited to their age, they are unsuited to strength. So the scope of Article 24 was first time considered by the Supreme Court in PUDI versus Union of India case. Here in this case, the person was engaged in the SCR works, that is about the construction industry, and it was being contended by the state that since the construction work is not being included in the schedules of the hazardous industry, so if any children below 14-year of age is being employed in the construction work, then it is not violative of Article 24 of the Constitution. The Supreme Court has rejected the contention of the part of state by saying that merely the fact that the construction work is not being incorporated in the schedule, that does not mean that construction work is not a hazardous industry, and if any person is engaged in such hazardous industry, then it will be violative of Article 24 of the Constitution. Apart from this, the most important case that pertains to Article 24 is the MC Mehta case, which case is also known the Sivkasi match industry case. Here the Supreme Court has given the detailed guidelines which has to be followed by the executives regarding the rehabilitations of the children who were employed in the any kind of the hazardous industry. Here the Supreme Court has identified the 6 kind of the hazardous industry, that is the match industry, diamond polishing industry, precious stone polishing industry, glass, brass beer and the carpet industry, lock making industry as well as the slate industry. And Supreme Court has directed that if any employer has engaged any children who is below 14 years of age in any such kind of industry, any such kind of work, then for rehabilitations of that, the specific fund was being created, and that fund was being named as the Child Labor Rehabilitation Welfare Fund, and every employer is required to deposit 20,000 rupees, and whatever the interest income that will be earned by the deposition of that money, that will be utilized for rehabilitation of the children, that will be utilized for the providing the education of children. And the most significant aspect of the MC Mehta case was that it was being directed that whether it's an unorganized sector or organized sector, if any children is employed there, then in lieu of that children, the employer will be obligations to provide employment to the same kind of work in which the children was being employed, and the children is being given right to name any one person of the family who will be deployed in such kind of work. So in this way the Supreme Court has tried to protect the right of the citizens against any kind of exploitation, whether it's a physical exploitation, social economic exploitations, under Article 23 and 24 of the Constitutions.
Okay, so I hope friends it was quite explanatory with cases. He has explained all the provision that is given in the Constitution of India, constitutional safeguard against prevention and detention. So I think you have got the point. With this word we conclude the lecture, and I thank Dr. Rakesh Kumar for giving such a wonderful lecture on this very topic. Thank you very much.